How Don't Ask, Don't Tell policy affects military readiness. Introduction. The Don't Ask, Don't Tell policy, DADT, came into effect in 1993. The DADT policy does not allow members of the U.S. military to divulge their sexual orientation, especially if they are bisexual or homosexual. This policy does not allow service members who are lesbians, gay, or bisexual to serve in the U.S. military. This is because such acts would considerably negate morality as well as discipline upheld by the military. The decree itself does not prohibit asking service members about their sexual inclination. There is a significant compromise regarding this policy, which remains a contentious issue in politics. Before this procedure came into effect, there was a decrease in the percentage of military persons sent home for homosexuality. Since 1993, this number has increased tremendously until 2001. Evidently, the DADT substantially affects military readiness as well as unit consistency, thus the need to exude care. Over the recent years, significant proportions of Congress members have articulated interest in making alterations to the Don't Ask, Don't Tell policy. There are two bills, S. 3065 and H.R. 1283, discussed in the 111th Congress. These bills would substitute the DADT procedure, putting in place a policy that does not distinguish individuals as per their sexual orientation. Gates announced amendments to the law of 1993. He voiced that a flag officer or a general is the only person allowed to discipline military members who exhibit homosexuality. A third party can only render such information under pledge to individuals like counselors, lawyers, or psychotherapists. Such information cannot be used in proceedings aimed at discharging military staff. Background analysis. During the presidential campaign in 1992, Bill Clinton, who was a contender then, promised to eradicate the DADT policy if elected. The policies that existed then had been in effect since Carter's management. Homosexuals were not allowed to serve in the armed forces. Several policymakers and the general public sturdily rejected this response. In response, in early 1993, Clinton initiated a short-term accord that gave the Department of Defense, DoD, a chance to explore the issue and come up with a draft executive order that would eliminate discrimination based on sexual inclination. Following the proclamation of the interim compromise, Clinton mentioned that the Joint Chief of Staff assented to eliminating questions about sexual inclination from the enlistment application. One of the constituents of the accord was to delay the enactment of legislation until a congressional appraisal was complete. The Senate and the House Armed Services Committee reached a consensus after several hearings on the theme, in May 1993. The selected approach did not allow the DoD to make inquiries regarding the sexual inclination of the military. They needed to keep homosexuality to themselves, if not, one would be discarded from the service or applicants would be denied the chance to join the service. Eventually, on the 19th of July, 1993, Clinton announced the new policy. It is essential to note that Don't Pursue was not included in the president's statement. Not only did it say the opposite to the president's policy, but also seemed to hinder the enforcement of bylaws and laws that implement the entire policy. This is by restricting the function of the military through Don't Pursue. Les Aspin, who was in charge of defense then, reviewed this concept at a hearing. He articulated that individuals would concede their same-sex inclination without risking examination or discharge. However, he later mentioned that, in the case of an examination, such statements could turn into plausible grounds for discharge hearings. The policy announced by Clinton was largely based on sexual inclination, which has led to concerns regarding the expedient classification of the term. It became subject to different interpretations. An ambiguous interpretation of the policy led to the signing of the FI 1994 National Defense Authorization Act into law. According to this novel law, a military member would be discharged if he or she was associated with homosexuality. The same would happen if an affiliate admitted they were homosexual or even bisexual. This also applied to an affiliate who went into a nuptial with a person of comparable sex. The law made it simple to ask recruits about their sexuality, having been banned earlier. Discharge of the new DoD policies for the accomplishment of the new law took place on May 22, 1993. The words used in these conventions showed that the person in charge of defense wanted to integrate limitations in the statute as well as the president's aspiration to allow homosexuals into the military. The term homosexual orientation in the policy was later deleted following the admission of William Perry as the new Secretary of Defense in 1994. Recent developments. In January 2010, Obama articulated his goal to work with the legislature to abolish the statute that barred homosexuals as well as bisexuals from serving in the military. After extensive conferences, the relevant authorities reached a consensus. In February 2010, during the Senate Armed Services Committee hearing, the Secretary of Defense and Joint Chief of Staff's chairman announced that homosexuals would be allowed to join the military. The announcement of significant changes regarding the implementation of the Don't Ask, Don't Tell policy took place in March 2010. DADT policy is quite discriminatory and therefore disrupts military readiness as well as national security. It also puts members of the U.S. Army serving overseas at considerable risk. Several homosexuals and bisexuals have served in the U.S. military in the past. The question pertains to whether Americans will continue lying about their sexual inclination to serve their country. The Military Readiness Enhancement Act, H.R. 1283 of 2009, and S. 3065 of 2010 would abolish the policy regarding same-sex orientation in the military that is currently in place. It would bar Homeland Security and Defense Secretaries from discerning members of the military as well as applicants based on their sexual preference. Additionally, this act would allow the reappointment of qualified individuals previously discharged for homosexual or bisexual acts into the military. Most importantly, the act would need both secretaries to put in writing the bylaws that oversee the demeanor of individual members in the military as well as impose them without focusing on individual sexual preferences.